we are pleased, Paul Newell and myself, to have you all here. It's a mixed audience, but it's more interesting, I think. Paul Newell, who is professor of antitrust at UCL, and myself, Alain Strowel, professor more of IP at UCLouvain, but as well in Brussels. We thought it would be interesting to combine our specialization area on this topic, which is at the interface between patent law and competition law. It's a hot topic and an interesting one because the issue whether patent settlements, and in particular settlements with a transfer value or pay-for-delay settlements, are anti-competitive or not, is an issue which is not only at the interface between IP and competition law, with interesting questions like what's the exact scope of patent, is there an extension of the scope of the patent, and in how far should competition law encroach on IP rights or not. But I think it's as well a topic which has a legal content, and we'll see that there are very recent legal developments in different parts of the world. But as well, it has a lot of policy considerations, I think, behind it, in particular concerning the justification of IP and competition law. It involves as well, of course, a legal analysis, but as well some economic analysis. And that's why we have in one of the panel at least an economic expert. We'll see as well that the issue involves the relation with regulation. So outside IP, outside competition law, the framework, and in particular the pharmaceutical regulation framework, plays quite an important role to discuss the issue. And we'll see that the issue, when it's conceived within, for instance, the US framework, with the Hatch-Waxman Act, and more will be said about that, might be conceived a little bit differently because of those different regulatory environments. So it's an interesting topic, but it's as well a topic which is really in the news and in three regions. So we have selected the development in the US, and at the end we'll start with the US. Here you have some reference to the basics of, first of all, the law in the US. It's partly for the students too, because we have provisions like Article 1 of the Sherman Act against agreements that restrain of trade, which of course are very similar to the framework we have in Europe with Article 101. In the US there have been a split between several courts of appeal, and that's the reason why the Supreme Court decided to take a case, and on June 17 of this year, the court issued its activist decision, which is interesting, and it's up to date, so we'll discuss it. I won't say more on that. We have a particular, of course, regulatory context in the US. In the EU, it's very different. We are not that far, in the sense that there are not that many decisions. But of course, and there will be a reminder, there has been a long process which started probably with the pharmaceutical inquiry a few years ago. And there is only one Lundbeck decision which will be presented by the European Commission, among others, and discussed later. But it's only, sorry to say that, only a decision of DG Com, so there is no court decision yet, and we'll see what's the content of this decision, with another regulatory context, of course, and there is no additional incentive in Europe for the first generic company to settle. And then we have Korea. I think it's interesting to open to view to other parts of the world, especially when there are developments which are very interesting, and we are pleased to have Professor Lee coming from Seoul, who will speak, and I'll leave that for him because I'm definitely not an expert on Korean law, who will speak about the GlaxoSmithKline case, which is, as far as I've understood now, in appeal before the Supreme Court. So we might have an interesting decision as well that we have, I think, to take into account. You cannot do competition law without doing comparison between different regions of the world, I think. And one of the issues, of course, behind this conference is how to bridge the gap, if you have to bridge it. Maybe you don't have to. One of the issues, I think, is that the rationale, of course, of competition law is very different than the rationale of patent law. I mean, if the objective is to increase consumer welfare, probably then you have to fight till the end agreements which do not allow to lower the price of drugs. And that's probably the main objective of DG Competition in its ongoing cases. But there might be, of course, a risk. As an IP lawyer, I always think that there might be a risk in the sense that you focus too much on the existing market. You don't have to reduce all the incentives for the future. So that's always the debate when you have a conflict between competition and IP. But of course, you have a lot of issues with IP, and there is, as you know, a tendency to overprotect and to extend the protection of many IP rights, and that's really an issue here as well. We have other institutional issues that we discuss. It's a problem that because you have the two issues involved, but you have different institutions which are in charge and competent. So, for instance, is a competition authority able to assess the strength of a patent? That might be one of the questions. And on the other side, it's sometimes difficult for the judges, for the judiciary, to assess all the economic impacts of some competition cases. Okay, that's all for a brief introduction. Now, what about the design of the conference? Basically, we have 3 panels with 3 speakers. The first panel, I call it the professor's panel, is a panel which intends to set the scene and discuss the most recent case that I just mentioned. Then we'll have a second panel to see what is the point of view of, I think, the 3 main categories of stakeholders, and that is the originators, the generic companies, but as well, and it's very important here, to have as well the voice of the consumers. The third part is the discussion panel, where we'll further discuss the economic aspects with an economist, as well the patent policy arguments, and as well, of course, the competition aspect. So we have, a lot of experts here, and I thank them to be here. So, for setting the scene, before the 3 main speakers on the recent legal developments in 3 regions, and we'll start, as I said, so we changed the order of presentation. We'll start with the US, and then the EU, and then Korea. But before that, we have a presentation by Mrs. Zakova, who is replacing Monsieur Pifot today, who could not come. So she will do the keynote presentation to present the state of the thinking, probably, of the Commission and the state of the cases which are in the pipeline right now. So we are very pleased to have her. Just a few words about the documents you will receive if you register. You received the file. There is in your documents biographies of the different speakers. So we'll be very short here in presenting the speakers because I've put, I think, enough information in this review of the speakers. I have to thank as well these institutions because Margiapsis is not part of the UCLouvain or my university, Saint-Louis in Brussels, but we have close connections and they are well located close to the European institutions. That's why we decided here to have the conference today here. And I think that's it. So I thank all the speakers, first of all, and I give the floor to Mrs. Zakova.